We had a really special oral argument at the U.S. Court of Appeals for Veterans Claims on April 29th. It was an en banc oral argument, which means that all of the available judges were there for the argument, minus one who recused herself. Zach previously argued this case last summer before a panel of 3 judges, but then the court sua sponte decided to send it to an en banc panel.
CCK is one of a small number of organizations that has a dedicated CAVC litigation practice. Most other firms and veteran service organizations practice primarily at the VA and at the Board of Veterans Appeals, filing what we call administrative appeals. The CAVC is a separate entity from the VA in that it's a federal appellate court, which requires the ability to practice federal litigation, which includes filing briefs, participating in oral arguments, and just being able to handle an appeals practice generally. The majority of CAVC cases are decided just on the pleadings, which means that a single judge reviews the briefs that the appellant wrote and that the Secretary's counsel wrote defending the board decision. The judge essentially reads both arguments and then decides which is more persuasive. That's what the majority of the CAVC decisions come to. CCK typically handles between 3 to 7 oral arguments per year. This is particularly high volume for a CAVC practice, especially considering the depth and complexity that our litigation team takes on.
We had a really special oral argument at the U.S. Court of Appeals for Veterans Claims on April 29th. It was an en banc oral argument, which means that all of the available judges were there for the argument, minus one who recused herself. Zach previously argued this case last summer before a panel of 3 judges, but then the court sua sponte decided to send it to an en banc panel. We don't know why, but the case involves a really important issue of continuing public policy involving the Appeals Modernization and Improvement Act of 2017 and what Congress intended the agency to do when the agency was transitioning from the old legacy appeal system to the new modernized system.
Preparing for an oral argument is a multi-step process, and the first step of that process is often determined based on whether or not the court has ordered us to answer any specific questions. Sometimes when ordering an oral argument, the court will direct the parties to a specific case that they want to discuss or ask specific questions about the pleadings to clarify the issues before it. For this argument that happened on April 29th, it was a little unusual because it was an en banc argument. And so the first argument that was before a panel of 3 judges did have a specific question asking the parties to address a recent case that had come out between our pleadings being filed and between the argument being scheduled. And so the court specifically wanted us to address the impact of that new case. But the en banc argument did not have any specific questions that the parties were directed to answer. Once we select the attorney who's going to present the oral argument, the strategy development is a full team process. We'll walk through what the opening statement should be, the key strengths and weaknesses of the case, key facts that we want to highlight, and we try to figure out what the judges are going to ask based on what the judges have previously asked in past oral arguments or what they have written in single judge decisions.
Usually we prepare for a case like this. First, we'll have a meeting. The whole oral argument team will get together and we call it a walkthrough. We talk about the issues, what points we really need to hit in the argument, any other things we need to go over, questions that are lingering in the back of our heads that we need to be able to answer if they come up in the oral argument. Then we'll have our first moot, and this is the first time that we actually run through the argument as though we were standing there in the courtroom. Whoever is arguing the case as first chair will be there and pretending like Zach Stoltz is Chief Justice Stoltz, and our colleagues or judges, we call them Judge Zelmer, Judge Stoltz, Judge Odom. Also, we will have whoever is second chair. The second chair has to be available in case the first chair gets hit by a bus on the way to the argument. The second chair has to be able to argue it. So the second chair is always present at all of the moots. Then we generally have somebody play VA. It's usually an associate attorney who has been here a few years and is starting to get ready to perhaps argue his or her own case in the near future. And then, of course, we'll have 3 judges. And then we'll go through the first moot. Usually it's pretty rough. We have to do a lot of changing things around and clarifying and perfecting our points. The first moot is usually the most difficult for the person who is planning to argue the case as first chair. It really is just the rough draft of the argument, so it's during the first moot that you're really going to be able to identify the weaknesses in the argument, what needs to be changed, what needs to be reworked. But you're also going to really be able to identify some of the strongest arguments. What are the most effective points? What do your colleagues seem to be struggling with? And can you answer that question in a way that will bring your colleague along to your side as though he or she were the judge? So once the moot is over, the first moot, you go back to your desk and you rewrite your intro and you workshop your points. Maybe sometimes I talk out loud. I say my answers out loud just to see how they hear and like get used to it coming off my tongue. And then in the second moot, things usually go a lot smoother. It's usually closer to the day of the argument. You've spent many hours reworking and workshopping your answers and your intro, and usually walk away from the second moot feeling pretty good.
The CAVC is located in Washington, D.C., so the attorney arguing the case and usually 1 to 2 of our colleagues will travel to D.C. the day before the argument, at which point they'll do some final prep work. Usually it depends on what the attorney arguing the case wants to do. Some find it more useful to rest. Others will review their case notes, their opening statement, and sort of walk through potential arguments that they want to make the next day.
How do I feel now that the argument is over? Well, number one, relieved. And, I feel like it went well. I've been thinking about this theory for years now, and ultimately I feel like I could answer each of the judges' questions. Whether they agree or not is something we'll find out, but ultimately that's what an oral argument is. It's just a conversation with the judges about what must be a complicated legal issue if you're before a panel of 3 judges, and even more so if you're before a panel of 7 judges. So ultimately, my goal was to answer questions and to have a conversation, and I think that I achieved that goal.
After the oral argument, the panel of judges will deliberate the case and eventually issue a written decision, which will become precedential case law. There's no set timeline for when the judges need to make this decision. Sometimes we've seen cases come out as quickly as 1 month after the oral argument, and others take several months to a year. It all depends on what the judges are deliberating and whether or not they can come to an agreement quickly. During this time that we're waiting, we're just keeping an eye on the docket, keeping an eye out for the email from the court to indicate that they've made a decision, and we're also keeping in touch with the client to let them know that we're waiting on a decision.
I'm proud of the team we have assembled at CCK of attorneys and legal professionals. CCK is responsible for over 115 precedential decisions at the Court of Appeals for Veterans Claims and at the United States Court of Appeals for the Federal Circuit. We have an abundance of talent and experience.